pass further amendments? Well, Mr. Speaker, the answer to that really is quite simple. As has been indicated, and as happened actually in 2013, that he referred to, the process under which jurisdictions are assessed, or the mutual evaluation process, which is undertaken by CPATF, is an ongoing process. It's a process that all 24 member countries of CPATF has to undergo. And as has been indicated, it is a form of peer review. Now, there's nothing complicated or indeed sinister about it. But the reality is that as time goes by, and there is a continuous process, there's continuous change, FATF, that's the international body to which CPATF is aligned, comes up with new provisions or requirements that each jurisdiction must conform with. And in particular, when one is coming up to the mutual evaluation, as part of that process, there are special steps and procedures that occur. Generally around 6 months before the on-site examination, and Dominica is currently, as you've heard, undergoing its on-site. Roughly about 6 months before, the Secretariat, CPATF Secretariat engages with the jurisdiction, in this case Dominica, and begins to map out the way forward to that on-site. And in our case, we had engagements around about November, and we had a continuous engagement with the CPATF Secretariat. And in February, we received and had to deal with what's known as a technical compliance questionnaire, which is a substantial document of a number of hundred pages, which the jurisdiction had to engage in that. The technical working group did the necessary work, research, and responses to respond to that questionnaire. That's a substantial body of work, Mr. Speaker. It's not that people are sitting around twiddling their thumbs doing nothing. There's a lot of work that's been done by many people, most of them public officers, who get criticized and vilified on occasion, unfairly and unjustly. And they work silently in the background, oftentimes without getting any praise, acknowledgement, and some may say without getting sufficient monetary award or reward. But Mr. Speaker, they are working, and they're working diligently. The purpose of that work is to ensure that Dominica, as a jurisdiction, adheres to the recommendations and regulations and requirements that it has to, so that we can ensure that we are doing our part to protect Dominica and our financial system, but also the international system as a whole, because we are part of that system. So, Mr. Speaker, of course, an element of what is happening is to satisfy the requirements of CPATF, but it's also to satisfy requirements that are essential to our progress or development and that are essential to us as a jurisdiction. But it is in the process of this ongoing review that takes place in that confined 6 months or thereabout that one gets to examine all of the legislation in detail in a manner that one would not ordinarily do, because it should stand as a matter of common sense that in no jurisdiction can it be expected that those 15 volumes that are there can be gone over in minute detail on a day-to-day basis. So it is when one is undertaking the sort of exercise that has been going on over the past number of months, using the relevant legislation against the recommendations as they have been revised and updated by the international regulatory body, that one looks at each recommendation, one looks at the relevant legislation alongside it, one sees to what extent one is in compliance, to what extent one may be deficient, and to what extent one would have to adjust one's legislation to address that deficiency or those deficiencies. And out of that comes these regulations, these bills, these recommendations to address those issues. Now, Mr. Speaker, that is, in summary, the process. So it is not possible or realistic to expect that these things could have been addressed many months ago, because it's only when one does that fine-tooth comb operation going through the laws that one gets to identify these issues. So that deals with that point, Mr. Speaker. The other point that I wanted to address, Mr. Speaker, is this, that a member spoke about effectiveness. And it's a good point, the effectiveness, because we can introduce legislation, we can enact legislation. But of course, if that legislation is not effective, it's questionable as to whether that is really a viable exercise. But that, Mr. Speaker, is one of the elements of this fourth round of mutual evaluations that is taking place, because effectiveness as a component, a significant component, was only brought in relation to the fourth round. So what is happening now is one has to have the legislation and other requirements as a framework, and then one has to judge the effectiveness as to the output, what comes out of it. And so that leads, Mr. Speaker, to the issue, again, an insinuation that they are not prosecutions. Well, they are prosecutions, and there have also been convictions. I don't have the specific figures, but I'm sure that those are figures that could be produced if it is that the members on the other side believe it is of sufficient significance. No doubt they will table a question at some point on that, and they will get an answer from the relevant technical authorities. But I can say, without fear of contradiction, that there have been and are ongoing prosecutions, and that there have been convictions. I can also say, Mr. Speaker, that in amongst what we are dealing with today is a recognition of the need to constantly update and to increase the effectiveness. That is why, Mr. Speaker, Clause 4 of the bill that we are now considering, the Money Laundering Prevention Act of 2022, Clause 4, which deals with an amendment to Section 3 of the Parent Act, one will see that it says, Mr. Speaker, a person, which would be subsection 3 of Section 3 in the amended form, a person who is guilty of an offense under subsection 1 or subsection 2 is liable, A, on summary conviction to a fine not exceeding $500,000 and to imprisonment for a term not exceeding 7 years if he is a natural person, and 2, a fine not exceeding $5 million if he is a body corporate, and B, talks about the fine on conviction on indictment in relation. Now, if one looks at the substantive piece of legislation, Mr. Speaker, one will see that at Section 3, as it currently stands, it simply says a person who is guilty of an offense under subsection 1 or 2, an offense, no reference to summary, is liable on conviction to a fine not exceeding $5 million and to imprisonment for a term not exceeding 10 years. So that's only dealing with a person. It doesn't address the corporate person or the legal person, and it doesn't address the issue of summary offenses. Now, one of the significance of that latter point, Mr. Speaker, is this, that it is far more difficult and challenging to prosecute indictable offenses. That is to say, for those who don't understand it, indictable offenses are triable only in the High Court. You have to have a preliminary inquiry into that. It's in the magistrate's court, and then maybe if the magistrate's court believes there's sufficient evidence for a trial, it then goes up to the High Court. There's another process in the High Court. Time, and also resources, and also challenges, and greater difficulties in getting a conviction. So the introduction of a summary offense, Mr. Speaker, is indeed a significant step in seeking to address the issue of effectiveness so as to increase the probability of those prosecuting for money laundering to have the opportunity of being able to secure more convictions. That is further underlined and indeed emphasized, Mr. Speaker, by Clause 7 of this same Amendment Act, which amends Section 28 in subsection 2 by deleting the words liable on conviction and substituting the words liable on summary conviction. So, Mr. Speaker, this piece of legislation is doing precisely what my honorable friends on the other side of the House have indicated they would like to be done, which is to increase the effectiveness of our money laundering legislation. So I'm sure that I will hear them all cheering on, Mr. Speaker. Well, you see, Mr. Speaker, this is where we have it. I mean, the honourable member for Salisbury says on paper. How do you help somebody like that? I don't think you can, Mr. Speaker.
Very difficult. Very difficult.
No, Mr. Speaker. Other members also made reference to, the manpower or personal power or human resource. Now, the reality is that we are a small jurisdiction, and sometimes, Mr. Speaker, in our efforts, and I say our to be friendly, but I'm really speaking of the members of the opposition, and in this misguided perception of opposing, rather than support, which is what happens in many other jurisdictions when you have this type of legislation, both sides of the House recognize that this is a national issue. It is not a party issue. This is a national issue. If Dominica is challenged with sanction, whether you want to call it blacklisting, which I don't like because as far as I'm concerned, blacklisting is associated with everything negative or bad is supposed to be black. I prefer, Mr. Speaker, negative listing, but that's me. So I'm not into the blacklisting stuff, but in negative listing, if we as a country are negative listed, the result of that is not going to fall on Labour Party supporters, or even opposition supporters, or even people who have no political persuasion. It will fall on all Dominicans. So this is a national issue that you should be looking at. Is this in national interest? Yes or no? If yes, support it unequivocally. Don't support it with ifs and buts and maybes, unless those ifs, buts, and maybes are genuine. Unless those ifs, buts, and maybes are genuine. You should be making suggestions to improve the thing, not simply wishful, like if. If you don't know if the thing is a problem, why are you raising it? Why are you raising it? Mr. Speaker, I really, as it is today, as may have been seen from my earlier intervention, I really am losing patience because I feel that all of us are adults and all of us are well aware of the role that we should play in this house and in this society. And it is really annoying to see that we have a situation where we come to the House time after time, and there is no attempt in most instances at bona fide contribution. If you take your mask off, I'll be able to watch you in your face even better.
But I'm not sure about that.
I said a while ago that I really am fed up, and that is exactly what I am, and I am not taking any prisoners anymore, Mr. Speaker. Mr. Speaker, reference was made to follow your leader now. Your leader took his bag and go. Follow your leader now. He took his bag and go. Follow him now. Okay, well, sit down there and get some wisdom. Mr. Speaker, reference was made to political will. The idea that anybody can realistically suggest that this government has not demonstrated political will in relation to money laundering and other criminal offenses, but we're dealing at this moment with money laundering, is absurd to the highest degree. Mr. Speaker, the legislation that this government has brought to this House to pass in support of ensuring that money laundering regulations are as tight as they may be is clear for all to see. And indeed, by their own pronouncement earlier, they acknowledged that. Mr. Speaker, it is very difficult to understand the craven ignorance displayed over and over again. I will sit down, but not before I address you verbally in this House, because you all need to understand that this House is a debate chamber. If you want to have your political speeches, they are available on the political platform, and that's why you all are constantly in difficulty with the Speaker of the House. It doesn't matter who they put as Speaker of the House. They can get an apostle to put there. You all have a problem because you all do not understand their rules, and you must follow the rules. So, Mr. Speaker, the Honourable Member for Rosa North would like to know the relevance. The relevance, Mr. Speaker, of this is that money laundering, and in particular, this bill, the Money Laundering Prevention Bill of 2022, is a solid piece of legislation which will go a long way to assisting us going forward. I should just say this, Mr. Speaker, maybe two final things. One is that at this point in time, I should let all members of this House and those who are listening understand the ongoing nature. We are in the fourth round. Dominica, we have the on-site. The assessors from CPATF are here for the rest of this week. They shall leave. When they leave, they will give an oral initial report. They will return, and then in a short space of time, they will give a first draft of a written report. We as a jurisdiction will have the opportunity to respond to that first draft. Again, we have a timeline within which we have to respond to that first draft. They will take into account all comments and recommendation submissions. They will submit to us a second draft, which we will again have an opportunity to respond to as a jurisdiction, and they will thereafter conclude the final report, the mutual evaluation report. That report, Mr. Speaker, will be considered at a plenary, all being well, or certainly scheduled to be considered at a plenary in May of 2023, that's May next year. At that plenary, the jurisdiction will, of course, be required to, if you will, defend or position. The report will be presented to the plenary, which consists of all of the 24 jurisdictions that I've referred to in the Caribbean, and including Venezuela. And they'll be present, IMF, UN, United States, Canada, United Kingdom, France, all these various other jurisdictions as have an involvement. And really, what actually happens is a critique of that report on the status of Dominica's anti-money laundering and countering of financing of terrorism and countering of financing of proliferation report. And of course, we hope that the report will be favorable to this jurisdiction. As I said earlier, it's in all our interests. And Mr. Speaker, I really do hope that, despite the challenges that we've had so far this morning, that I really do hope that we can recognize that we as a people, there are times when we have to come together, to work together for a collective good and a collective benefit. And there are other times when, of course, the political battle can take place. But we have to be able to understand what issues are national interest and issues which we all must rally around and work towards, and what issues are issues that we can squabble over. And with those few words, Mr. Speaker, I wholeheartedly support the bill.
Mr. Speaker, I rise to conclude this debate before this Honorable House. Firstly, let me just warn all members of this Honorable House. You must be very careful if people are very short. And I've learned that for the dexterity and the quickness, Mr. Speaker, and to say further that the Attorney General was also SSU trained like myself. Mr. Speaker, having said this, Mr. Speaker, thank you. I think that if we're serious about fighting anti-money laundering issues, we must applaud this government for being transparent and responsible and support this matter, Mr. Speaker, before this Honorable House. But Mr. Speaker, I intended to be very short, but I want to say something, especially to the young people who were born in the late 90s, because all they know is the Dominican Labour Party in office. But Mr. Speaker, there's a history to the governance of this beautiful country that must be therefore put into context. Having said this, Mr. Speaker, we're just battling with the lingering moments of COVID-19. It has been said that COVID-19, Mr. Speaker, is the most devastating pandemic to hit this global space. I want to defer to say there's a next pandemic that is more destructive. And that pandemic has been conceptualized, researched, and developed by human beings. The pandemic of misinformation and disinformation by people, politicians who cannot win an election, Mr. Speaker. And that is very dangerous, Mr. Speaker. And there's no vaccine for that pandemic, Mr. Speaker. Having said that, Mr. Speaker, having said so, Mr. Speaker, when I listened to the leader of the opposition who exited just now, one gets the impression that the Financial Action Task Force as an intergovernmental apparatus to establish and to formulate and to put policies in place to place mandates on governments to fight money laundering and other predicate offenses, just, Mr. Speaker, emerged during the lifespan of the Dominican Labour Party. Having said so, Mr. Speaker, the Financial Action Task Force came into effect in July of 1989 at a G-Summit meeting in Paris, France, Mr. Speaker. From my research, I may be wrong, the Prime Minister was 17 years old. Yes. From my research, I may be wrong. Ian Douglas, the Honorable, was 19 yeyears old? 18. Or 18, just so to speak. All right. Yeah. The Dominican Labour Party came into office in 2000. May their souls rest in peace, Honorable Mr. Douglas. In February of 1999, the CFATF, which is an instrument or an auxiliary from the regional standpoint of the Financial Action Task Force, came to Dominica to do its on-site investigation. By so doing, Mr. Speaker, a number of government officials were interviewed, namely the Minister for Finance, among others, the Chief of Police, the Head of Customs, etc. And the report was damning to Dominica's approach insofar as its failure to have the requisite infrastructure to fight money laundering. For matter of fact, the report said that there was a dichotomy of views expressed between the Minister of Finance then, government officials, and the police and other law enforcement agencies. What does that mean, therefore? When the ministers were asked, were there instances of money laundering in Dominica, they said zero, or nearly so. When the police and custom officials were interviewed, they said there were instances of money laundering. As a consequence, this small government was blacklisted, Mr. Speaker, because of the failure of the government then to put systems in place. I'm saying that to say that the 40 recommendation, it did not say it, plus 9, you have 9 more now. But the 40 recommendation from the Financial Action Task Force started in 1989, Mr. Speaker, not 2000 and beyond, Mr. Speaker. And it is this government first started with Honorable Prayer Charles, may so rest in peace, and I can speak with that with some absolute authority. Because there was no FIU, the Financial Intelligence Unit. What we did then, the then Attorney General, Mr. David Bruning, and as the assistant to the Prime Minister, your humble servant, I was tasked to be the coordinator for the establishment of the FIU. We used the Barbados model, and St. Vincent did the same thing. Then subsequently thereafter, Mr. Reynolds, a police advisor, was sent to Dominica to look at our infrastructure, etc., etc. Then we had a consultant from Australia who came to Dominica for about 4 months. Then, in 2001, the Financial Intelligence Unit was formed under the Dominica Labour Party, Mr. Speaker. At that initial stage, we had 3 officers, Mr. Landa, the director, and the great Mr. Wati as the deputy director. Honorable Petras passed on. Then Honorable Prime Minister Roosevelt Skerrit emerged, Mr. Speaker. And since then, we have done so much to improve our capacity in terms of the legal framework and the physical infrastructure. The AG made reference to that, Mr. Speaker. Then, not only have we had the FIU, but we have the supervisory authority established under Section 7 of the Money Laundering Prevention Act, which actually speaks to the financial unit as the authority. And under Section 15 of the said Act, establishes, Mr. Speaker, the advisory committee. And this amendment we spoke about seeks to broaden this committee, to bring in the Director of Public Prosecution to add a greater scope and higher level of competence. That is what we're doing. That is transparent, and the opposition needs to support this measure and stop speaking from both sides of the mouth, Mr. Speaker. Mr. Speaker, having said that, the leader of the opposition made reference to 2013. But I can recall, in 2016, we came to this honorable house to amend the Proceeds of Crime Act. And under section 61.1, which placed an obligation of people coming into Dominica to declare in excess of a certain amount of money. We went again, Mr. Speaker, in 2020, and they made the Eastern Caribbean Central Bank the authority to regulate domestic banks. This government has been very, 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 very responsive, Mr. Speaker. Very, very, very responsive. And I think it's a shame on the members of the opposition, knowing that that's your country, knowing that there's a team on island doing on-site interviews, and you're trying to blacklist the country. So what is happening right now? We're getting kudos from international space, but you have members of the opposition trying their best to get Dominica blacklisted. That is not Dominican. That's not part of the Dominican's tradition, Mr. Speaker. And they ought to be ashamed of themselves, Mr. Speaker. Mr. Speaker, I haven't said that. No, I know you have a beautiful suit. You have a beautiful suit. That's why you're so happy this morning. A beautiful suit. Okay? And you must pay attention to the rules of the House, Mr. Speaker, when you dress it. I can talk. Okay, yeah. This suit is so much. That's why you're so happy this morning. Beautiful suit. Mr. Speaker, I haven't said that. But I'm going to put it on me, eh? I haven't said that, Mr. Speaker. I haven't said that. Mr. Speaker. Mr. Speaker. Mr. Speaker. I have the highest regard for the Financial Intelligence Unit, Mr. Speaker. For a matter of fact, Mr. Speaker, the last time I took a plane, just before COVID-19, I hope that you're not listening to me. I had the opportunity, Mr. Speaker, to go to St. Lucia at the Council of Ministers meeting, and I was pulled into a room by the head of the U.S. mission. And I was told that Dominica has the best FIU in the Eastern Caribbean. The best. And at no time, when requests have been made to improve the human resource component, whenever I go to the Prime Minister, he even give ideas as to how we can augment the FIU, Mr. Speaker. That is the commitment of the Prime Minister and the Dominican Labour Party. We have nothing to hide. So do not come then speaking in tongues like we involve in money laundering. Having said that, I hope one of the orders that was tabled in this honorable house, I hope all of us are paying close attention to it. Because when you're trying to bring money under the disguise of humanitarian grounds, Mr. Speaker, that is precluded by virtue of this order. And strictly speaking, once there's a parent offense, even if the attempted offense is not spelled out in law, there's an attempt. So what transpired there, the saga just before your last election, was a clear case of attempted money laundering, Mr. Speaker. Yeah. Yeah. If we are interfering as the minister and the prime minister, I don't get involved in those things. That's the last thing I would do. A government who has been said to be, the prime minister is a dictator, and you're signing an MOU, yes. And for less, your signature, documentary, and real evidence, understand? And your operators are recorded, real evidence, and there's a buffer. There's no buffer. There's no buffer because you signed the MOU. So let us not get into that. There was an intended buffer, but that intended buffer was busted. Yes. When they busted properly, but patented. When it's not me, it's not me. See? That's what he said. So that burst. So, Mr. Speaker, having said that, of course, 110% confidence in OG. And then you come in this honorable house.
You cannot mention, do not call members of the public name in this honorable house. I've ruled on that. I have no tolerance for this. Nice. Nice. Great. Let's move.
That. Which is very uncommon for us from the West, where very energetic and straightforward, to the point, no nonsense where we don't throw stones at the people. Mr. Speaker, he made reference to a matter. One of the amendments he made some years ago allowed for cases of money laundering to be dealt with civilly before the magistrate court. So this money you're referring to has been forfeited, and as we speak, it is lying in the forfeiture account, Mr. Speaker. This is a responsible government. Now, I want to just give some credence to what I said just now when I referenced that the FIU is the best in the Eastern Caribbean catchment. Mr. Speaker, the FIU of Dominica has confiscated the most fund in the whole Eastern Caribbean, Mr. Speaker. And Mr. Speaker, if you permit me, just to reference from 2017 to 2022, the Financial Intelligence Unit has successfully preferred 7 money laundering prevention charges against people, Mr. Speaker. 7. As we speak, 3 are real, and 1 is before the High Court by way of paper committal. Is this a government that is afraid, or the FIU is scared to pursue people? And to say that, Mr. Speaker, from 2017, for the same period I just referenced, there have been 35 civil cash forfeiture. 35, Mr. Speaker. We have to commend the FIU for the hard work, Mr. Speaker, and working in the custom. 35, Mr. Speaker. And in terms of the quantum, Mr. Speaker, of the cash that we're talking about in so far as forfeiture is concerned, you're talking about $7,510 that have been forfeited and placed into the government account, and has been used, Mr. Speaker, to do the following, among others. The Prime Minister just now made reference to the 5 scanners that was paid for over $2 million paid for by that fund. Vehicles for the police some years ago, the same. And the list continues and continues, Mr. Speaker. That is what the FIU is doing. That is what a responsible and transparent government is doing to fight money laundering offenses in this country, Mr. Speaker. So, I'm saying, and the Prime Minister, a former school teacher, was right. You don't come there and commit yourself. If you're not sure about something, you ask a question. But I find the young senator, John Finn, never, Mr. Speaker, never liked asking questions. Very young. Okay? All right? Never likes to ask questions. She always comes like a jab. You understand? Ready to fight and say what she wants. Jab, jab, jab. And when you come like a little fly and try something, she gets vexed. The Prime Minister is right. So I'm providing you now with the statistics. And to say that nothing is happening to fight money laundering crimes and other predicate offenses, Mr. Speaker, is very unfortunate. I see the head of the FIU here. I want to commend him, Mr. Speaker, and commend the staff for their tremendous service to country so far, Mr. Speaker. As I close, Mr. Speaker, going back to what is the real responsibility of a government insofar as its intent to fight money laundering and other attendant offenses. I made reference to and gave a historical perspective to how the FIU came about. But even after we did that, Mr. Speaker, we came in, this government came in, and the laws that we had on the books were deficient. One of those laws is the Proceeds of Crimes Act. We had Mr. Fitzroy Drayton from England who came down.
5 more minutes.
That's cool. And spent months in Dominica going through all our different pieces of legislation to help us to fight money laundering. And that is how we came out, Mr. Speaker, and amended the Proceeds of Crime Act to deal with predicate offenses, Mr. Speaker, among others. So this government has been working all the time, Mr. Speaker, to fight money laundering and to say further, Mr. Speaker, and the AG is right and the Prime Minister is right. Because when the Financial Action Task Force started in July of 1989, it started to establish and promote policies to fight to fight money laundering. And then, Mr. Speaker, in 2001, it expanded its mandate to deal with issues to combat terrorism, Mr. Speaker. And in 2012, it again expanded its mandate to deal with weapon of mass destruction and the proliferation of such, Mr. Speaker. So as the Prime Minister rightly said, it's a constant battle. So it's a dynamic process. And then we have to continue to do what we have to do, to look at our legal regime and to support our legal regime with the requisite infrastructure to help us to fight money laundering and the other offenses that you just referenced, Mr. Speaker. But having said so, Mr. Speaker, we should be applauded for acting in mitigation. And as the AG rightly said, our review in May 2023 may say that we have to do more, but we are confident that we continue to demonstrate our intent to do everything possible to put the brakes on people who want to commit money laundering and other predicate offenses, Mr. Speaker. I commend this matter to be put on the door.
This concludes the debate. It has been moved and seconded that the bill shortly entitled the Money Laundering Prevention Amendment Act 2022 be read a second time. Those in favor? Those against? The ayes have it. The bill will now be read a second time. The bill now stands committed to a committee of the whole House to be considered clause by clause. Committee stage without amendment. The question is that the report of the committee and the bill be adopted. Those in favor? Aye. Those against? The ayes have it. Yeah, read it over. The mic was off. It's good. Put it on. Make it get green. Okay, stop. Good. Proceed.
Mr. Speaker, I move that the bill shortly entitled Money Laundering Prevention Amendment Act 2022 be read a third time and passed.
Seconded.
It has been moved and seconded that the bill shortly entitled Money Laundering Prevention Amendment Act 2022 be read a third time and passed. Those in favor? Aye. Those against? The ayes have it.
Money Laundering Prevention Amendment Act 2022.
The bill has been read a third time and passed accordingly.
Mr. Speaker, I move the second reading of the bill shortly entitled Proceeds of Crime Amendment Act 2022.
Seconded, Mr. Speaker.
Mr. Speaker, this amendment is closely linked to the amendment of the other two acts that have been debated thus far. Financing of terrorism and combating financial proliferation of weapons of mass destruction. Mr. Speaker, is a serious matter. Huh? No? No. Hmm? Yeah, that's it. That's it, yeah. I know it, Mr. Sir, I don't know. Yeah, that's it. Let me start over. That's it. Yeah. Mr. Speaker, this matter is closely linked to money laundering and the countering financing of terrorism and combating financial proliferation of weapons of mass destruction. As indicated before, this government, Mr. Speaker, is intent on taking a collaborative and holistic approach to combating financial crimes in this country. Dominica has also pledged to undertake the needed amendments to its legislation, systems, and processes to ensure compliance with the Financial Action Task Force 40 recommendations. And the punishment of fraudulent activities goes a long way in curbing on financial behavior, but must be, Mr. Speaker, undertaken in conjunction with ensuring that persons cannot profit from the proceeds of certain crimes. The Proceeds of Crime, Mr. Speaker, amendment bills comprises 10 clauses and seek to provide additional definitions, strengthen the Joint Anti-Money Laundering Advisory Committee, and to improve clarity and effectiveness of Dominica's anti-money laundering, countering financing of terrorism, and combating financing of proliferation of weapons of mass destruction legislative framework. Clause 1 and 2, Mr. Speaker, set out the short title and interpretation provision of the bill respectively. Clause 3 of the bill inserts 5 new definitions, including bank, proliferation, security, regulatory commissions, and supervisory authority. Section 1 sets out the short title, an interpretation provision of the bill. Clause 3 of the bill inserts 5 new definitions, including bank, proliferation, security, and regulatory commissions, and supervisory authority. Section 41 of the Parent Act, Mr. Speaker, is amended by Clause 4 by inserting a new subsection 5A. This new clause provides for and clarifies the type and form of information required to be produced under an order of the court. In particular, Mr. Speaker, the amendment provides for information contained by means of a computer, and it has to be produced in a visible and legible form. This amendment is needed since the courts have already ruled that law enforcement require access to information held in electronic devices such as computers, cell phones, among others. Clause 7 amends Section 59 of the Act to expressly empower the Attorney General to apply for caveat in relation to an application for property seizing or interim freezing order for the registrar to order entry of a caveat where it is appropriate. This addition, Mr. Speaker, further strengthens the Proceeds of Crime Act by ensuring that people who obtain property, including real property, by engaging in unlawful conduct or property that has been used in or in connection with or is intended to use in or in connection with unlawful conduct can be encumbered and ultimately forfeited to the state at the end of the proceedings. Mr. Speaker, it was discovered that there was a need to expand the supervisory regime under the legislation, and this is what Clause 8 seeks to do. Clause 8, Mr. Speaker, amends Section 60 of the Act which deals with the issuing of a code of practice. This clause expands the Anti-Money Laundering Act and the supervisory regime to include the Eastern Caribbean Central Bank and the Eastern Caribbean Security Regulatory Commission as the supervisory authorities. And this authority is provided with the responsibility for ensuring that the regulated entities comply with the legislative obligation under the anti-money laundering regime and provides direction on the imposition and disposal of administrative penalties. An administrative penalty collected by the advisory authority shall be paid into the asset forfeiture fund in the case of the unit, that is the financial services unit. In the case of the central bank, confiscated funds shall be retained for the use of the central bank for the purposes of its function, and in the case of the Security Regulatory Commission, be retained for the use by the Commission for the purposes of its functions. Mr. Speaker, it should be noted that the Financial Services Unit is the supervisory authority for the financial institutions and scheduled entities other than commercial banks. The Eastern Caribbean Central Bank is the supervisory authority for the commercial bank, and the Eastern Caribbean Security Regulatory Commission is a regulator of the security exchanges. Mr. Speaker, this amendment also seeks to broaden the scope of the responsibilities of some of the key agencies involved in this fight. Clause 9 amends Section 60A of the Act to add financing of proliferation to the scope of responsibility of the Joint Anti-Money Laundering Advisory Committee, along with the money laundering and terrorist financial activities. The committee, by two new subsections inserted by Clause 9 of this amendment, will also have the responsibility of advising the Minister on the development of national policies to combat money laundering, terrorist financing, the financing of proliferation, and coordinating actions to assess the national money laundering, terrorist financing, and financing proliferation risk. Clause 10 repeals Section 60B of the Act. This is needed, Mr. Speaker, to remove the unnecessary confusing existence of the same offense in two different pieces of legislation and differing penalties for the same offense. The repeal of Section 60B, therefore, Mr. Speaker, removes this duplication and clearly identifies and confines the offense of money laundering to that under the Money Laundering Prevention Act of Chapter 7303. Mr. Speaker, with this brief introduction, I commend this bill before this honorable House.
The bill is before the House for debate. Yes, Honorable Luge.
Thank you very much, Mr. Speaker. Mr. Speaker, there's three pieces of legislation we are here to debate: the Money Laundering Prevention Amendment, the Proceeds of Crime Amendment, and the Suppression of Financing of Terrorism Amendment. If, on an average, we come to this honorable House 3 times per year, we will always be behind in enacting these amendments. And that's one of the big problems we have. If you compare the sittings of the House in Dominica to other Caribbean countries, other jurisdictions, they meet on an average 10 to 15 times per year. But when we meet on an average 3 times per year, I can understand why today we're meeting in emergency session. Mr. Speaker, the Proceeds of Crime Amendment Act, Chapter 12, 29, is my view that it's a noble cause to come to this parliament to make these amendments, and that is why each one who's risen on the opposition side has already said that they support the amendments. But because we support the amendments doesn't mean we should just sit down. That's not our role. There are certain concerns that we have, we must raise. So in a democracy, I think we have to have the decency to listen to the parliamentary opposition, even if we don't like what they're saying or not. We're raising genuine concerns, and these concerns must be heard. Most importantly, in Dominica, Mr. Speaker, what citizens want to know is that when we come to this house,